Hi, I'm Monica Bay at the University of Florida, and we've been attending a fantastic e-discovery program, and I'm with Gordon Calhoun. Tell us a little bit about what you do for a living.
Well, I'm head of the e-discovery practice at Brisbois, a 890-person law firm with offices all across the country.
And which office are you in?
I'm in the Los Angeles office.
Oh, wonderful.
And where we are today is opportunity to talk about the future of e-discovery, which I think is critical to just about everyone considering the practice of law. E-discovery is everywhere.
As where are we going with e-discovery?
Well, I think e-discovery is going to become a dominant aspect of litigation for the simple reason that 99+% of all human communication is now electronic. And what lawyers do in litigation is all about finding evidence. And if the evidence is almost exclusively electronic, the lawyer who is not aware of how to deal with those issues is going to be ill-prepared to represent clients either in litigation or the courtroom.
And it's getting more and more complicated now. I'm just fascinated with the internet, what are they calling it, the Internet of Things.
Yes.
And everything as benign as people may not realize that their cars now have little black boxes, and even if you put Nest up, the thermostat, that can actually be information that no human has talked to, but it's already there.
Right. We started off with the email, which everybody is used to thinking about as being part of e-discovery, but we've since gone well beyond that. We're talking not just about documents that are created in the Microsoft environment, but we're talking equally about social media. That's become a real repository of information for all kinds of cases. It's become not just a personal injury issue, but also one in the regulated area of securities transaction. The SEC, for example, has published standards for how broker-dealers can communicate with their clients in the social media environment, recognizing that people will communicate with each other using whatever medium is currently before them. If they're in the office, they may use an email account. If they're calling their broker on the weekend, it could be on a Twitter account, it could be on a Facebook account, it could be on any Gmail publicly available email account. So the data is rather as undisciplined as people are and goes wherever people go. And part of the role of the litigator or the investigative attorney working on an internal matter is to track down that data and find out that which is important to the particular dispute or transaction in question.
And how does the technology we've just seen this explosion of more and more and more technology, how is that helping, and what are some of the challenges of having so much technology?
Well, I think the challenge is mastering the right questions to ask. The real problem is figuring out where do we have to go to get that which is relevant. And as you say, there's the Internet of Things. When we talk about even prosaic things like an automobile collision, we've got the black box in most new devices. We've frequently got video from surveillance cameras in the area. We've got pedestrians or other passerbys who take out their smartphones and take video. Bruce Jenner is a current example of a social celebrity whose accident in Malibu, tragic accident, was filmed from many directions by passerbys. We also have things like dashboard cams on EMT or first responder vehicles. Police officers are now wearing devices which capture the scene. So lawyers have to be thinking about where is data that describes the event about which I'm concerned, how can I track it down, how do I make sure if I'm plaintiff, for example, that data is preserved, because if I'm a defendant who learns about an event months or years later, I'm going to take the position that the failure to lock that down and preserve it has prejudiced my ability to defend the case. So anybody who's considering litigation needs to think about where does data about my dispute reside and what must I do to preserve that in order to protect my client's interests going forward.
Well, discovery certainly isn't what it was when I started doing it, when there wasn't an E in front of it. All of this is going to have ramifications on how law firms practice and litigate. But what ramifications are there for the students who are right now in law school? What advice would you give them if they are looking towards where am I going to start my career?
I think the answer there is be comfortable in the current environment in which you live. It's a very changed world from when I first began practicing law. We have all of the powerful tools that we talk about, predictive coding and so forth, living around us in our lives. Amazon.com, for example, is telling us when we place an order what we may also enjoy. Those technologies are involved in the practice of e-discovery. So the good news is those who've grown up in the last decade are familiar with many of the principles underlying e-discovery.
Yeah.
And it's intuitive for them. They don't face the difficulties people in my generation have faced in trying to retrofit into a modern world technologies about which we had no experience as
That is a
young
brilliant
attorneys.
statement, and I resonate to it thoroughly, having just retired from law technology news. But it's also really exciting, and everyone is able to, the good, I think, so definitely transcends the irritations in most cases.
Well, I'd say welcome to the 21st century. Being alive in the second decade of the 21st century is a true blessing. There are things that we can do that our parents and even my generation never imagined even 10 years ago.
Absolutely.
And e-discovery is simply a manifestation of that wonderful world in which we live, and we have to master that in order to deal with the disputes that lawyers are engaged to address.
Very nicely presented. Gordon, thank you. I'm
You're
Monica
welcome.
Bay, and thank you for watching.